In this last panel for the Harvard India Conference 2022, we are all extremely eager and excited to hear what our esteemed speakers have to say on this pertinent topic of improving India's justice system through technology. Before starting today's discussion, I would like to briefly go over some housekeeping items. We will kickstart the discussion with our respected panelists and moderator. Their conversation will go on for about 45 minutes, following which we will open the session for audience Q&A. We value our audience engagement more than anything, and we hope you will use this time to further probe the arguments made by our speakers. Please use the Q&A function you see on your screen to post your questions. You will have an opportunity to upvote questions. We respect and acknowledge the fact that there will be differences in perspectives, but we humbly request our participants to kindly keep the comments, questions respectful and civil, such that we can all learn and grow from each other's ideas. We also request you to please tag us and use the hashtag ICH2022 to tweet and share your favorite quotes, insights, and moments from our panel. In our panel, we have Honorable Justice D.Y. Chandrachud, who is a sitting judge in the Supreme Court of India. He is also the chairperson of the E-Committee of the Supreme Court. Under his guidance, the Indian judiciary has made substantial leaps of progress in utilizing technology to augment access to justice ecosystem for citizens. We also have Shri Amitabh Kant, who is the CEO of Niti Aayog, the apex think tank of the Government of India. Mr. Kant is well known for advocating the use of technology to transform public services and governance. He has been pivotal in creating a cross-ministerial consensus for introducing and implementing the online dispute resolution in India. The session will be moderated by Mr. Desh Gaurav Sekhri. He is a former OSD law at Niti Aayog and was the convener of the Interministerial ODR Committee, which released its report in December 2021. He has recently co-founded the Sports and Society Accelerator, which focuses on sports policy and law domain to help stakeholders across India. With this, I hand it over to Desh Gaurav Sekhri for the panel discussion. Desh.
Many thanks, Satvik, and thank you to the India Conference at Harvard's organizing team. We are truly privileged to have with us the Honorable Justice D.Y. Chandrachud and Mr. Amitabh Kant. We have limited time and a lot to learn, so I'll get right to some initial questions. I'll start off with a question for Justice Chandrachud. Sir, it is widely acknowledged that one of India's major successes for justice in response to the pandemic was the transition to virtual courts. With India being the global leader in matters heard, how would you foresee the role of virtual courts or a hybrid model going forward?
Thanks, Desh. But I must be candid when I admit that the shift to virtual courts or a hybrid model would not likely have happened in India without the onset of the COVID-19 pandemic. At the very least, it would have taken a few more years, or it would have been introduced in a limited measure in a specific court or courts or locations. There is nothing wrong with that approach as well, since it would have allowed the system to be perfected in a particular ecosystem before being deployed everywhere else. But I truly could not have imagined a scenario where the entirety of the Indian judiciary went virtual overnight at the same time. It is important to remember that the Indian judiciary is not just the Supreme Court or the High Courts in various states, but also numerous district courts and quasi-judicial bodies spread across the entire nation. What the pandemic did was force the judiciary to innovate, because if we had not done that, the citizens would have lost access to justice and access to systems of justice. Keeping this thought in mind, the entirety of the Indian judiciary became virtual. Even though this transition, so to speak, was due to the unforeseen circumstances of the pandemic, I think it really opened up everyone's eyes to the reality that the entirety of the Indian judiciary could operate virtually. That is an idea no one would have believed way back in 2019, or it would have most certainly been met with extreme skepticism. However, it is hard to be skeptical about anything once it's actually done. Having said this, I'm cautiously optimistic that virtual courts or courts operating in hybrid models will have a significant role to play moving forward. I'm optimistic because the judiciary, lawyers, litigants, and the administrative staff have started becoming used to such a system over the course of the last 2 years. They appreciate the real-life benefits, such as the ability to enter proceedings from any location. In fact, I always say that the Supreme Court has truly become a national court now. The ease of case management and reducing one's reliance on physical files. At the same time, I'm kind of cautious in my assessment because due to the circumstances surrounding the virtual court's introduction during the pandemic, it is understandable why many today would presume a return to the status quo which prevailed right before the pandemic descended. I'm also conscious that digital penetration and literacy of the Indian society definitely is not at a stage where attending virtual hearings would become a natural process. Thus, while virtual courts or hybrid models may not ever go away entirely now and will most certainly be welcomed in the higher appellate judiciary, I do acknowledge that it will take longer for them to gain proper acceptance at the grassroots level. Hence, the role of the higher judiciary, to my mind, becomes even more crucial in driving that conversation forward and providing the right tools along with training. So I enter upon this phase of the pandemic and look beyond with a sense of cautious, if not guarded optimism for our future.
Thank you, sir. That's extremely encouraging and enlightening. I'll just quickly follow up with an observation and a question related to the work that has been happening on technology enhancement, some of which you'd just briefly mentioned. Accompanying the increase in capability for virtual court hearings were several key initiatives to help make the lives of citizens easier using technology. Such measures would also conceivably help reduce the growing pendency in courts. I'm sure the audience would love to hear your views on the potential of a technology-enabled justice delivery system and areas where you feel the key interventions could take place.
Well, the potential for a technology-enabled justice delivery system in India is already on display today. I understand that our audience today may not all be from the legal profession. So let me first explain what a justice delivery system is all about. A justice delivery system is not just limited to the courts, but it extends to others who are an important part of the process. Public prosecutors, the police, forensic science laboratories, and the prison administration, amongst others. All these institutions have their own role to play in the process of justice delivery, and each of their roles is complementary to the other. For instance, without the work of the police and the forensic science labs, the public prosecutors would have no case to argue before the courts. Hence, all of these institutions have to work in tandem to ensure that all citizens are guaranteed justice. Now, the E-Committee of the Supreme Court of India, which I chair, has been working to ensure that the justice delivery system is constantly updated with the influx of new technology. The virtual hearings of our courts are complemented with the introduction of e-filing and the digitization of case records. We are also working on the N-Step platform through which services of court summons and processes are centralized through smartphones, which locate the GPS location of the person to whom the summons is being delivered, record the photograph, the signature, and upload it into a central server. So this centralization can reduce case pendency. Case management tools are now being offered to advocates and to litigants through which they can keep an easy track of their caseload. The judiciary is also engaging with other institutions, such as the police, through the interoperable criminal justice system. This project is a flagship project of the Government of India and the Ministry of Home Affairs, which allows for the data on the criminal justice administration to be shared real time between all institutions dealing with the criminal justice administration. So this not only avoids the duplication of work, but ensures that unavailability of information does not lead to unnecessary delay. Other than these areas, I believe another crucial area of intervention is the use of virtual platforms for recording of evidence. And this is particularly so in the context of commercial courts, where we are dealing with trans-border disputes and important arbitration disputes, where you will have witnesses situated across international boundaries. In a Supreme Court judgment, I previously noted, for instance, the benefits of using such facilities, especially in family matters, where parties may not want to be in each other's presence. One of the spouses may be in Bangalore, the other one would be in Silicon Valley. And we are now increasingly using mediation across virtual platforms. Another key area is the transcription of all records, all court proceedings, which will not only increase transparency, but would also serve as a neutral record of the case for the appellate courts, because this is one of the deficiencies in our court system, that we do not preserve records of arguments in courts other than what judges take down. Technological solutions, Desh, can still be further implemented to improve the communication between various institutions who are part of the justice delivery system, such as in the communication of bail orders, so that the moment a bail order is issued by a court, it should go instantaneously to the jail so the prisoner can be or the convict can be released on bail. And that protects personal liberty. This helps take away the undue burden upon the litigant and reduces any chances of delay as well. So all in all, we have these initiatives which we are now working on very closely. Particularly, I think the two key initiatives at present that the E-Committee is working on is digitizing the court records, and hand in hand with that, e-filing of all documents across the board. That's work in progress, but we are hopeful that we can really achieve this milestone very shortly.
Thank you, sir. And that's actually a perfect segue into my question for Mr. Kant. Mr. Kant, as Chief Executive Officer of the Government of India's policy think tank, we have been involved with and led several measures in the last couple of years using technology for enhancing the ease of access to justice for the common man. Could you share with us some of the key reforms in this area, spearheaded by Niti Aayog in collaboration with line ministries?
Thank you, Desh. Access to justice is actually a very major imperative for the Government of India and for Niti Aayog. In Government of India, we've been working throughout to advance ease of doing business and ease of living. In fact, we've been ranking Indian states on ease of doing business. Effective justice delivery is at the focal point of these two missions. The role of technology as a disruptor, the focus on good governance, the enhancement in ease of living are all aspects that correlate positively with high growth. If India is to grow at high rates for the next 3-4 decades, all these are very critical. And technology has the potential to greatly expedite access to justice for the common man. We in India have now prioritized technology, and we feel that it has the potential to provide large incremental value to a wide range of sectors, access to justice for all being a key sector. We in Niti Aayog run the aspirational district program. This covers 115 of the most difficult, the most backward districts of India. We don't call them backward, we call them the aspirational districts. And we do we believe in good governance through just real-time tracking of data, and we rank these districts on good performance. Through very competitive and congenial federalism, we have comprehensively addressed the development needs and transformed these 115 districts across 28 states, and we've seen massive progress on various developmental parameters. This was not possible when I was a district collector many years back. This is possible now merely because of the advancement of technology. Citizen-centric services that have been disrupted or perhaps irreversibly altered due to the pandemic have completely required a rethink. Access to justice is a key citizen need that requires a futuristic relook to enhance efficiency, equity, and ease. My belief is that technology will play a major part in ensuring these parameters see exponential improvements. The pandemic has forced a huge shift towards solutions that minimize contact and can be activated through technology, including the resolution of disputes. And I'm truly delighted that Indian courts are quickly adopting leading practices in a very sustainable and forward-thinking manner, particularly under the leadership of Justice Chandrachud as chairperson of the Supreme Court's India's E-Committee. I was particularly delighted to hear him say that we must look upon justicing not just as a sovereign function, but in the world of technology as a service which is provided to the community. And therefore, I have great hope that we are witnessing a very visionary period in the history of India's court system.
Thank you, Mr. Kant. And that leads me into my next question for Justice Chandrachud. Sir, as chairperson of the Supreme Court's E-Committee, you have led a transformational period in how technology is integrated into court processes, including, as you mentioned, through e-filing and e-payments of fees. The recently released draft strategy for Phase 3 has envisioned a much wider and deeper role for technology in the justice system. We would love to hear your vision for how Phase 3 can be impactful for the common man and be adaptable to the high courts and lower courts.
To provide some context for those who may not know about the work of the E-Committee of the Supreme Court of India, which was established in 2004, Phase 1 of the E-Courts project was geared towards providing the absolute bare minimum digital infrastructure in all courts, from computers to proper internet connections for over 17,000 courts that we have in the country. Thereafter, relying on what was achieved in Phase 1, Phase 2 of the project focused on providing technology-driven solutions, such as the National Judicial Data Grid, which provides details of pendency of cases across all high courts and district courts in real time. So just to give you one example of the statistics, we have data today of 40.24 million cases in India on the National Judicial Data Grid. Now that's a mine of data. We have data of 115.29 million cases which have been disposed of, which are preserved, which is preserved on the NJDG. And the total case records which are available on the NJDG, including pre-trial and pre-litigation, works out to about 164 million cases. So this is a huge statistic that we have really with us today in terms of the National Judicial Data Grid. In comparison to Phase 1 and Phase 2, Phase 3 of the project adopts a radical approach. It is in a sense radical because it does not envisage using technology to merely modernize existing processes. Because the true answer to our problems is not about really converting into an automated form what was hitherto being done on a paper or a physical format. Rather, its starting point is a system which is natively digital. It will seek to create and foster a digital system of all courts where new processes and solutions can be built to improve efficiency and improve the litigant's experience. By creating such a digital ecosystem, Phase 3 aims to make the litigant's experience with the judiciary more accessible. Phase 3, for instance, seeks to ensure that the relevant hardware and digital infrastructure come together to foster an ecosystem where efficient services can be provided to litigants. It aims to standardize the processes all over the country, which is again a problem Mr. Amitabh Kant just mentioned about our being a federal nation. So one of the challenges is that you have states across the country doing their own, finding their own approaches and means to integrating technology. But we need to understand that there has to be a common approach all across the country, consistent with federal standards. Now, in the process of standardizing the processes across the country, we want to ensure that the experience of litigants is not varied, and there is some degree of uniformity in experiences in terms of access to justice. Ultimately, the goal is not only to make the judiciary more efficient and transparent for the common citizen, but also to make its processes more accessible and less cumbersome. I also understand that the concerns of the digital divide in India continue, and offering digital services cannot be at the exclusion of those who do not have access to them. In fact, our lawyers, for instance, do suffer from the digital divide. Litigants do suffer from the digital divide. Therefore, one of our missions today is to set up what we call the e-service kendras or the e-service centers across India, which will provide basic electronic services to all litigants and every stakeholder in the system. the approach in phase 3 will also be consistent with the norms and standards of data sharing and user privacy, something that we have not done much work on so far, so that litigants do not feel compelled to give up on their data to access justice delivery mechanisms. Finally, I think it is important to remember that while phase 3 offers a radical technological shift of the justice delivery mechanisms, it is ultimately still based upon the principles of access to justice and the rule of law. Hence, the adoption of technology has to take place in a manner which furthers the human element in the administration of justice, which is based on access and the rule of law.
Thank you, sir. I'll turn now to Mr. Kant for my next question. Mr. Kant, there's been a significant effort by the Government of India towards promoting different forms of dispute resolution, with a special emphasis on mediation and online dispute resolution. Could you share with us some of the key takeaways and future recommendations towards broad basing ODR and mediation in India?
So Desh, online dispute resolution is a very fast evolving dispute resolution mechanism that uses technology not just to aid, but to proactively assess efficient and affordable justice delivery. It can be used as a mechanism for solving disputes outside of the formal court system in an affordable and quick way, particularly for small and medium value matters. In today's age of data-driven solutions and machine learning, ODR is more than just replicating existing processes online. And my view is that due to the pandemic, we will see a deluge of disputes in courts that will require expedient resolution. And that is why new innovation models such as online dispute resolution need explicit support. At Niti Aayog, we have worked extensively on measures that can help enhance efficiency and accessibility of justice for the common man. A key reform is a policy framework for online dispute resolution. We had a committee, high-level committee chaired by Justice A.K. Sikri to formulate an action plan for ODR in India. All the concerned secretaries were represented in this committee. I'm happy to note, to tell you that the report has been very well received by the stakeholder ecosystems, and all ministries have accepted it. And we are rolling out an action plan that not only enables ODR in a sustainable framework, but one that adapts and endures the test of time to become the first recourse for several categories of claims in a dynamic fashion. The report has recently been released and the roadmap is being prepared by us for implementation. Mediation too is an immensely important dispute avoidance mechanism, and one which is gaining prominence and priority in the Indian context. In India, the judiciary is leading the roadway to equitable justice through the e-courts mission mode project. And courts across India have set up court annexed mediation centers, including the Bangalore Mediation Center by the Karnataka High Court and Samadhan by the Delhi High Court. And during the pandemic, some court annex centers such as Samadhan have in fact led the way in adopting ODR through programs like online mediation project. Therefore, it could be considered to use the precedent of mandatory pre-litigation mediation as has been proposed in the commercial courts, rules which were framed to help resolve matters relating to commercial disputes, and use technology interventions to widen and deepen access and engagement. Justice Chandrachud has on quite a few occasions positively spoken about ODR and how it could be a vital cog in combating the clogging of courts. And therefore, the support of the Supreme Court of India and Justice Chandrachud in particular will be very critical for ODR and mediation, and his support will be truly invaluable in the days to come. Thank you.
Thank you, Mr. Kant. And I'll turn now to the always topical area of artificial intelligence and its integration into justice delivery and mechanisms. I'll start with my question for Justice Chandrachud. So, you had recently mentioned how technology should, and I'll quote, bring about a transformation, not just automation. And you'd also mentioned how the next step should be evaluating the prospect of using artificial intelligence in court processes. Would love to hear your thoughts regarding the role of AI in justice delivery and what global processes or uses you feel would be adaptable in the short and long run for India.
Desh, there is so much of artificial intelligence that we in the judiciary need to learn about from people who are outside the judiciary. And in fact, that is one of the reasons why we are actively engaging with civil society, with specialist bodies of the government of India. We don't really hold our cards close to our chest. And I think that really is the key, to have this broad coalition where inputs come in from outside the judiciary for the betterment of the judiciary. And we've been working very closely with Niti Aayog and the Department of Justice, the Ministry of Electronics and Information Technology, and we've got some great initiatives from them. Now, let me begin to really deal with this question by referring to what Professor Richard Susskind has said in his book, Online Courts and the Future of Justice. He puts in a little bit of humor and his own astuteness when he says that AI, he says, has become a verb. We can AI that is often said by people who would struggle to distinguish between a neural network and custard cream. Through this, what he's trying to highlight is that the over-reliance on AI being a one-stop kind of solution to all our problems poses some dangers for us. This is not to suggest that I do not envisage a greater role for AI going forward, but one must be careful in their assessment of what can be achieved in the short term and the limitations of AI itself. Presently, the Indian judiciary is already using AI in its virtual traffic courts, where challans or the traffic tickets are issued based on the footage captured from CCTV cameras in Delhi, for instance. This highlights the benefit of using an AI system for a task which may have taken longer time for a human being. For instance, in Delhi, the work of about 22 judges has been taken over by one single virtual court, which is manned by a judge. Another key area where AI systems can outclass human beings is their sheer processing power. That is to say, their ability to comb through large amounts of data and make connections that a human brain may not have been able to do. For instance, the government in our country is the largest litigant. The use of AI, if AI is deployed by government to find possible outcomes in pending cases of the government based on past outcomes, that would really give a huge way forward for government to resolve cases where it is a party to litigation. It was this ability which was utilized by IBM's Deep Blue to win against humans at chess in 1997, and then by IBM's Watson to beat humans at the American game show Jeopardy in 2011. Law firms in India and abroad are already using such AI systems in their due diligence operations, and the judiciary can consider it also. At the same time, I also believe it's important to be cognizant of the pitfalls attached to AI systems. For example, previous studies have shown that AI systems which provide guidance to judges on the risk assessment of offenders were biased against those who belong to the African American community. It is entirely possible that the AI system was just basing its decision on connections it found in the data provided to it, which in itself was bad data because it incorporated within it the years of systemic racial oppression. This brings to light the question of which particular areas the judiciary can AI be incorporated and its specific role in the judiciary. Whether it can entirely replace human decision making, I doubt very much, or just provide guidance to the judges, which is much more possible. Ultimately, I think the most interesting question will be whether AI systems in that sense can ever truly replace human judges like myself or advocates, or if they were to become sufficiently advanced. Such a question has two parts to it. First is the technical question of whether this could ever be made possible. Interestingly, following in the footsteps of its earlier programs, IBM is working on a project called Project Debater or Project Debater, an AI system. It's an AI system which, really speaking, should be able to debate and argue just like a human being. When Project Debater faced off against a reigning debate champion, it ultimately came up short, not because it did not have the right information in the right order for a cogent argument, but because it lacked the skill of persuasion. And every day as a judge, I know how much you are persuaded by just that little human element in the argument before you. While all judges and advocates are bound by the four corners of the law, a persuasive argument based on a unique interpretation of the law or of specific facts can always make a difference. However, assuming this technical issue is resolved, the second question is whether morally can an AI system make decisions about someone's rights? Now, that's the moral and ethical question. I believe that's a question we all have to consider as a society, and our answer to it today may not hold forth a few decades later, when we will be passing on the baton to succeeding generations of judges, when AI systems have become more advanced and common in all aspects of our lives. So AI does have very, very strong uses in the Indian judiciary, particularly considering the mine of data which we are using and which can be usefully deployed for finding patterns, for case management, for finding out trends. On the use of AI for finding solutions to individual cases, I would be much more guarded as a judge, because I would be very, very reticent about allowing the human element to be dispensed with or replaced in the justicing process. But yes, AI can certainly form a very important supplemental role for judges in deciding cases more efficiently by researching mines of data and giving them some trends on where the emerging provisions would lead to in the future.
Thank you, sir. And that, in fact, perfectly sets up my question for Mr. Kant on AI and its future. Mr. Kant, Niti Aayog has been leading the dialogue on artificial intelligence and innovative uses of technology in key citizen-centric sectors. Where would you feel AI and its allied uses would contribute to the enhancing of access to justice and the parameter of it extending to all?
Desh, our belief is that AI is now the future of technology. It is both transformative and revolutionary. We are adding an internet user every 3 seconds. We have the cheapest cost of data, 1/10 the cost of data as compared to US, 1/20th the cost of data as in United Kingdom, and therefore we are extremely data rich. But we need to become data intelligent. We had in Niti Aayog released the first ever national strategy for artificial intelligence for India in June 2018. We called it AI for social good. And our belief is that artificial intelligence needs to be used in the case of India for improving learning outcomes, for improving health outcomes, for ensuring that we are able to provide nutrition in a much better manner. And the challenges of India are unique. They are very different from the challenges of United States. We don't need a driverless car. We need to solve our problems. And if we are able to solve our social problems, we'll find a solution not for the 1.3 billion people of India, but for the next 5 billion people who are moving from poverty to middle class using technology and AI. And therefore, the challenge for India is to ensure that the AI adoption is not solely for purposes of commercial considerations, but it should in fact balance with the greater social good And that is very, very important. The ethical and responsible use of AI and machine learning for the advancement of efficiency enhancing can also be very increasingly embedded in legal and judicial process. AI has, my belief is that the Supreme Court has laid a strong foundation basis, which efficiency enhancement can be accelerated across functional processes. And this is one of the key reasons why justice delivery system in India is poised for transformative changes. AI will have a very major role in better implementation of several schemes like National Food Security Act, Manrega, Jan Dhan Yojana, PEHL, Pradhan Mantri Fasal Bima Yojana, Land Record Modernization Program, whole goods and services tax. All these are very critical, the use of AI. And, I also believe that tools derived from AI could help expedite the case flow management, unclog processes that slow justice down, and in many cases, ease administrative aspects of justice. The use of AI in courts, to my mind, should not envision replacing the wisdom, experience, and objectivity of judges like Justice Chandrachud in determining verdicts. I feel that in the conceivable future, there is no question of replacing human reasoning, logic, and intelligence of the judiciary with automation. But there are many aspects of technology that can be integrated with immediate effect. With all these successes and support of the Supreme Court of India, AI can become a very positive intervention when used responsibly to help expedite access to justice and enhance the experience and interaction for the common man who is really looking for timely and effective justice. Thank you.
Thank you, Mr. Kant. I'll turn now to a slightly adjacent topic, which is an aspect that will likely be a critical player in India's technology adoption journey, namely acceptance. I'll start with a question for Justice Chandrachud, along with a quick follow-up on the role eventually of mediation and ODR. So, while many strides are being made in terms of the implementation of technology, one of the key challenges ahead will be acceptance. And as you have also mentioned earlier, in the behavioral change component, what would you feel are the biggest opportunities and challenges ahead when it comes to integrating technology with basic and specific access to justice? And just quickly building on that, what role would you feel technology augmented mediation and online dispute resolution could perhaps have in helping reduce the burden on the courts?
Well, as it so happens, over the last weekend, I was talking to one of our Chief Justices who has done a lot of work in his state on integrating technology in the work of the court system. And something which the Chief Justice of that state told me was very interesting. He said, well, when we are talking of paperless courts, we must really ensure that the younger lot of judges, the moment they enter the system, work only on paperless courts, which is really an indicator that the future really belongs to the young. And therefore, we need to tap those who are more tech savvy, namely the younger lot of judges who are now entering the system, to really spearhead the motion, spearhead the movement. The role of the e-committee is to facilitate by access to justice by using technology as a tool. However, if all stakeholders, such as litigants or advocates, are just unwilling to accept those changes, then it is ultimately a failure, because then introducing it may just have the opposite effect of limiting access to justice. And that's something which we are working on, the behavioral change, both within and outside the judiciary. At the same time, there's cause for very great optimism, because I do firmly believe that the opposition to the introduction of technology-driven solutions is not at that stage in India anymore. Individuals are naturally in favor of the status quo and suspect any deviations, but they're not opposed. They're not entirely opposed to change on any principled basis. The bigger challenges we face are those of digital penetration and digital literacy. In respect of digital penetration, it is about making affordable broadband available to all citizens along with technology to access it. The e-committee is aware that it is a difficult goal to achieve, which is why we have installed e-Seva Kendras in the high courts and district courts through which litigants can access various e-services. For instance, just the other day, the Madras High Court proposed that they're going to have these e-service kendras or e-service centers at bus stands across the state of Tamil Nadu. And they took permission in the budget from the e-committee to do that. And we said, please go ahead and do that. This leads to the issue with digital literacy, where many individuals are not equipped to interact with digital solutions. Indeed, this is what a bench of the Supreme Court, which I was a part of, noted in its orders related to the COVID-19 vaccination drive in India. And we requested the government to reconsider its decision to limit booking of vaccination slots through digital means only. And the government came very positively and said, no, we are not going to confine it only to booking digital slots on for vaccination. That was really the dialogic role between the Indian judiciary and the government of India through using the court processes. In order to increase digital literacy, the E-Committee conducts numerous training programs and workshops in coordination with various high courts and state judicial academies for judges, for lawyers, clerks, and for court staff. Lawyers, clerks are a very critical element in the system because there's a feeling amongst lawyers, clerks that they may be displaced in this technology drive. So we need to reskill them and get them to work within the judicial system based on technology. Another massive challenge facing the integration is that technology itself is constantly evolving, and we are often left with playing catch up. But I'm hopeful that once we get sufficiently caught up, we can try to keep pace with the technological development therefrom. In terms of the opportunities, I think we were provided with the biggest opportunity during the onset of COVID-19, because it forced everyone to adopt digital solutions as a matter of necessity in the Indian judiciary. Once these benefits have become apparent, it provides a fertile ground for future technological integration as well. It is also my hope that the new crop of lawyers who graduate from law schools will be more enthusiastic about adopting technological changes and will also be more comfortable with them from the word go. Ultimately, I believe that if a certain level of technological comfort is inculcated as a part of legal education, it will definitely affect the attitude of lawyers as well. And I also want to stress here that this is really it's a cooperative venture between the judiciary on the one hand and the expert agencies of the government of India on the other hand, because as Mr. Amitabh Kant also stressed very, very strongly a short while ago in his presentation, this emphasis today on making the Indian judiciary more attuned to technological change, more flexible to incorporate technological change, I think is very important because it sends the message of a modern, evolving judiciary, and not a judiciary which is really hidebound by procedures which were laid down for us when many of our procedural laws were enacted in the 19th century. So there's more to it than just technology. I think we are driving home a message of change within the judiciary, of making our processes, our thought processes, the behavioral processes, more attuned to becoming flexible in our adoption of technology.
Thank you, sir. I think I speak for many when I say that listening to you is not just an incredible learning, but your pragmatic views on opportunities and challenges are both encouraging and realistic. So with that, I'll get to my last set of questions, and they're closely aligned to what you had just mentioned. This is an area where I personally have witnessed magic at work. So, and the aspect that I seek to address in this last set of questions is one of collaboration. For this, I'll start with Mr. Kant. Sir, collaboration has been a cornerstone of the Niti Aayog, and that has continued with the dialogue on technology and justice. How do you think this collaborative spirit can best be optimized, given that the Supreme Court has been completely open in adopting technology and also in working with key stakeholders?
Desh, one of the key collaborative efforts we will lead will, of course, center around online dispute resolution and, where applicable, the role of mediation and technology for broad-basing dispute resolution options. And I think we'll have to do a lot of work with the state governments in this regard. I think the nature and extent of the support we receive, both intra-government as well as across the board, has really showcased how the movement towards access to justice will have to be completely collaborative. At NITI, we have engaged not merely with the state governments, we've actively worked with several high courts for knowledge exchange and sessions on the role of technology to help dispute resolution. The openness and the progressive nature of the Supreme Court, as you know, as very clearly elucidated by Justice Chandrachud, allows for this to be a collaborative effort, and in fact, with all stakeholders. And I would really like to say that the draft vision document for phase 3 by the Supreme Court of India's E-Court Committee is very, very path-breaking. It is a progressive and a very transformational roadmap for how technology and justice can be intertwined and optimized. And this chaired by Justice Chandrachud, the E-Committee's vision is a very positive step for bringing to the forefront the need for technology and technology augmented processes to help to truly enhance justice delivery for those who need it the most. I am of the view that a holistic approach, replete with checks and balances, principles and values, has to be driven to make technology a key driver to solve several of the current issues before us today. The magnitude of the problem is enormous, but you know, we are at a very momentous time in moment in time, and where India has proven to have the capability of adapting and adopting cutting-edge practices. The Supreme Court's transition to virtual courts and automating processes is highly commendable, and through key reforms such as ODR, mediation, automating processes, and bringing in technology for all non-invasive forms of accessing justice, we are in a position to collaboratively work together to enhance the ease of living, to bring in ease of doing business for each and every Indian that requires any form of interaction with the justice system. So I really feel that this is a great, unique opportunity. This is a unique time where India can make transformative changes in a collaborative manner.
Thank you, Mr. Kant. I've just been informed that the time has flown and we're, I think, pretty much past our allotted time for questions. So I've been asked to introduce a couple of audience questions. I'll start with a question for Justice Chandrachud from Richa. The question is, judicial process re-engineering at the back end is critical. Given limited judicial bandwidth, could third-party outsourcing of back-end processes with enhanced use of technology, including AI and ML like the HMCTs in the UK or similar in China? So the sovereign decision-making system remains with the judge, but all other processes can be outsourced.
This is a very valid point actually in this in the question, which is the core functioning of a court is taking judicial decisions, and everything apart from that really are the non-core activities. Court systems are purveyors of data, and we are purveyors of a huge amount of data. And there is a great amount of potential for these non-core activities of the courts to benefit greatly by the involvement of technological solutions, technology-driven solutions, which come in from outside. And in fact, in various aspects of our functioning in the recent past, whether it was in terms of, bringing up the Vision 3 document, which we put out for public comments, whether it was in framing rules for live streaming of cases, whether it is on preparing a digitization SOP to ensure that the digitization which we do doesn't suffer from technological obsolescence 10 years down the line, or whether it's in terms of data privacy and security issues, or inclusion of the differently abled, of of whether it's visually challenged or the hearing impaired. So in a variety of situations, the E-Committee is increasingly looking to tap the resources of non-judicial actors from civil society and from government outside the judiciary. So I think this is certainly a very valid point which has been made, and we are more than keen to allow others to tap their own experience and potential for the benefit of the Indian judiciary. In fact, one of the areas which we've already started working on is to have open APIs. So we have opened up the APIs to governmental institutions presently so that they can tap the data for managing their own litigation. And by, I do believe that we can open up APIs, we can have open APIs going beyond governmental institutions as well. So I certainly concur with that line of thinking.
Thank you, sir. I have a question now for Mr. Kant. The question is, has Podia been adopted by ministries, and what will be its effect on government litigation in courts?
Sudesh, one of the key learnings from the OTR committee deliberations, and all secretaries were represented in the committee, which was chaired by Justice Sikri. I was particularly delighted by the proactive way ministries were keen to adopt ODR at scale, particularly the Ministry of MSME, the Medium and Small and Micro Enterprise Ministry, because they felt that small businesses really suffer and ODR will be of big help to them. So as we roll out the framework and actionable adoption guidelines, I am confident that all the stakeholders, particularly the ministries, will embrace ODR for external and internal matters as a routine to my mind in due course.
Thank you, sir. I have one last question, and this is again for Justice Chandrachud. So since you have brought the language of, and this question is by Aaron, since you have brought the language of environmental rule of law into Indian jurisprudence, what do you see as some of the trade-offs and possibilities of technology in the justice system when it comes to environmental matters?
In relation to environmental matters? Well, before I deal with environmental matters, let me just say this, that we are huge consumers of paper. The amount of paper and the amount of carbon footprint that is generated in the Indian judiciary can really benefit greatly by the reduction of our dependence on paper and moving to technology. For instance, almost all my case files now are given to me digitized in the electronic form. And the entire case notes that I have for hearings in the court are not on paper. They're all on the electronic form. So the huge benefits in terms of that for the judicial system. On the environmental rule of law, that's a notion which we have increasingly propounded, because when we began our environmental jurisprudence, we focused on initially the polluter pays principle, the public trust doctrine, and now we have moved beyond that to the environmental rule of law, looking at environmental litigation as an overall perspective of the rule of law. And I personally believe that using greater technology in decision making would help us even in promoting the environmental rule of law, which seeks to balance development with the environment. I mean, it's not one-sided. It contemplates that, well, you need to protect the environment, but it also understands that you need development in a poor society. Using AI and AI-driven techniques, I think, is very important, because in many of our environmental cases, Desh, we delve into areas where there's a lack of scientific certainty, and there's a mass of very often conflicting data. And I think AI, with the potential which it has to suss out which are the different and very often conflicting strands in decision making that we as judges come to confront, can give us better outcomes, can give us better assessments of what leading trends in technology are, about the impact of many of our activities for the future. So specifically in the context of the environmental rule of law, I do believe that there is a great amount of scope for the use of technology-driven solutions.
Thank you, sir. Sadly, we're all out of time, but this has been a truly enlightening and riveting session. I would just like to thank both of you for being here and for patiently walking us through India's journey through technology and access to justice. It's been a rare honor to hear from two of the most progressive decision makers of India. So thank you again for your time. With that, I'll pass it on to Satvik Mishra, who's a key member of NITI's work on ODR and technology for justice during his time there, and is a passionate advocate for access to justice in his own right. Also, a very quick thank you to Nirali, Anand, and Nitin. Satvik, over to you.
Thank you, Desh. Thank you, Mr. Khan. Thank you, Justice Chandrachud, for this fascinating session. This has been extremely enriching. We couldn't have asked for a better final session to the Harvard India Conference 2022. You may drop off if you'd like. Next up, we have a final statement from the terrific team of Harvard India Conference 2022. Please do join us for that final session.